je vais inviter les...
And without further ado, I would like to invite the next two speakers to take the floor. Julian, and I will be quite brief. Julian CLARENNE is a professor at the FSR. He's currently visiting teacher at the UCL Saint-Louis Brussels and teaches the constitutional law course to bachelors. He's supposed to go to Canada in a while, if I'm not mistaken. And MATHIAS 𝐿BERHOUMI holds a bachelor's degree in philosophy and doctorate in legal sciences. He is a professor at Université Saint-Louis, where he teaches constitutional law. And the title of their exposé is The Collective and Individual Dimensions of Accountability in Belgian Constitutional Law, and they will refer to a series of biased ideas. What about individual responsibility? Is it legal fiction? But it was a kind of teaser, and I hope it will give you the wish to listen carefully to them. Well, thank you very much. And I'm part of the organizers, but it's important to have an opportunity to thank your colleagues, of course. Although I'm part of the organizing team, I assume it is essential to thank my colleagues. We did work for FNRS. I would like to thank my colleague, to thank Fanny and Virginie and Elena, who were indeed at the very origin of this program, of these 2 days, and we were actually delighted to have the opportunity to attend the seminar. I'm not going to further elaborate on our project, but I would like to set the scene regarding our presentation. We in Belgium, we are sometimes too much focused on the federal state, the development of fundamental rights, and because of that, we tend to lose sight of a series of issues which have to do with political law. Most of the time we don't focus so much on it because we are fully aware of the epistemological difficulties and problems. And there is also a deficit of responsibilities, or at least that's what we feel, which might feed in turn deficit in terms of trust and confidence. And it's quite difficult, as you know, to govern without any trust. So our proposal was here to have a kind of interdisciplinary approach, to have the opportunity to do a kind of benchmarking exercise between the different disciplines with a view to better measure what was at stake from the point of view of trust and political responsibility. Well, that's Friday afternoon, and we will have something which is a little bit down to earth. If you don't mind, we will refer to positive law. Other elements did give us a broad overview of the situation, so now we will be a bit more down to earth. And it does not work well. The remote control has some problems. Well, never mind. We are in Belgium, and we all know that we have a parliamentary regime with the political responsibility of the government in front of the Parliament Assembly. And this political regime might be translated into different ways, into different devices or mechanisms. Of course, it would be interesting to do a kind of benchmarking exercise, but if it had been the case, we would have seen that we have different mechanisms which would allow us to implement political responsibility. And we have different types of member states, those with collective responsibilities, and other member states, like Belgium, where we do have mechanisms which do allow for a collective resignation or individual resignation in the case of ministers. Of course, there are some nuances to be made. It does not mean that we do not have political responsibility in the very first group, but there are some specificities which have to be conceptualized, which is not always the case in the second group where Belgium is. As mentioned by our president, because he read carefully our exposé a while ago, if we refer to constitutional law and the issue of political responsibility, most of the time we try to describe in a very technical way and sophisticated way the way we can adopt motions of confidence or motion of distrust. And it is true that sometimes we can see that at the end of the day there is such a gap between theory and practice, or between the rules and the practice, that we can consider that at the end of the day there is no genuine individual responsibility, because the individual responsibility does melt into the collective responsibility of the government. It is a quote by Francis Delperret, who was present here yesterday, by the way. And individual responsibility is a kind of legal fiction, as mentioned by François Perrin from Liège, who is usually very often quoted in this type of seminar. And I would like to come back on what was said in the previous exposé. We cannot measure the effectiveness of these rules on the basis of the resignations or the amount of resignations of government. And I think it was well indicated by previous speakers. But we have other methods in terms of accountability or political accountability to measure those different elements. The political responsibility is something which is gradual, although we might have to tackle with a series of ambiguities. We have a kind of a binary approach, either you have trust or not, but we also have on top of that a series of techniques which go beyond this notion of trust and mistrust. And it does indicate how important it is for all those techniques to live together, and they do highlight the role of the Parliament and refer to mainly to a threat which is probably much more effective than the genuine use of those measures. Anyway, we have to tackle the reality of this political responsibility. These last years, we had a series of cycles. We have sometimes a great deal of individual resignations. That's what we have seen, and in some cases in political law, we know that analysis is really important. We need to carry out a detailed analysis of the situation, and we need to highlight the principle of political responsibility. And that's another teaser for another written paper. It would be a bit too long, to go into the nitty-gritties, but we need to take on board the collective responsibility and the individual responsibility in the Belgian case. And we need to refer to those clichés which are partly true, but not always. I think I can speed up a little bit, because I've just covered my introduction, actually, and I still have many other points to cover. And given that the remote control is not fully operational, it does make my task a bit more difficult. Well, this being said, we have a series of legal rules which might feed in those clichés and a deficit in terms of conceptualization in the field of constitutional law. So we will cover 6 for the first one and 4 for the second one. But given that the chair of this session is quite strict, I don't think I will have the opportunity to cover all of them. But never mind. Let's set the scene first of all and refer to history, if you don't mind. For those of you, at least, who are less familiar with the history of Belgium and the constitutional law in Belgium. Well, if in 1831 we did refer to the individual responsibility, it is because it is something which is quite old. In the past, we had division of Article 106 of the Constitution. Well, Belgian people don't know it by heart, I assume. We insist upon the fact that we need to refer to the king, and the objective was not to have another body completely apart from the king, because the king had an opportunity to get in touch with ministers in the exercise of power. But when the constitution was adopted, the situation slightly changed. So we have authors who are experts in constitutional law who decided to associate all that to this notion of responsibility of ministers, and I would like to refer to Orban from Liège as well, so to have a huge tradition in the field of constitutional law in Liège, as you can see. But the main problem would be to decrease responsibilities. In case of mutual blame, it is quite difficult to determine who might be sanctioned, and it means at the end of the day that people always blame someone else, and it's quite difficult to identify who is the person to be genuinely blamed. That's something which was mentioned or stated 100 years ago. There was a lack of collegiality, a lack of collegial approach, indeed. And when gradually it was decided that some important political decisions had to be discussed at the level of the Council of Ministers, there was some reluctance with distinguished authors. I'm not going to mention them because they're not from Liège, Molitor and others, but I'm not going to name them. As I said, they're not from Liège. But those people, or those authors, were, well, how can I put it? Yes, were not quite favorable to this approach. They considered that there was a kind of dilution of responsibilities. Well, we know that this evolution and the role played by the Council of Ministers is something which did take place outside of the legal text. And I think we will have the opportunity to come back on that, but I would like to refer to the Convention and covenant of the Constitution. So this approach is not enshrined, let's put it bluntly, in the Constitution. And what is interesting here is that even when the federal institutions did emerge, we had to start from scratch to a certain extent. We had to determine the role and responsibilities of the regional bodies, etc. And it meant that we had to insist upon the fact that decisions had to be made jointly by the governmental bodies. And we insisted that on top of that there was an issue of individual responsibility and collective responsibility. It is much more the case for federal bodies or federal entities. I will come back on that in a while. But it was a possibility to trigger both responsibilities from an individual point of view and a collective point of view. So this dual dimension in terms of responsibility was maintained, although this clear will was never detailed in any theoretical provision, nor by the federal entities or by all the other authorities. So it means that it's quite difficult for us to determine where does start the responsibility of minister regarding decisions made by collectively. So things are a little bit blurred, I must say, but I will not go into the detail because it is a way to escape some responsibilities indeed. Well, we decided to refer to this paradoxical situation because we have more and more importance given to collective responsibility with, at the same time, an approach related to individual responsibilities. And I would like to come back on the previous speaker. The rationale is the following. Trust is granted collectively through, but although we have elections of ministers or appointment of ministers and a point related to the individual responsibility. Sorry, that's worse than what the president done, because we have seen all the rest of my presentation. There is no more cliffhanger, if I may say so. Well, first of all, what I would like to mention here is that when we did review the Constitution in 1993, there was a clear objective at stake. i.e. to focus on the collective and joint responsibility, because we wanted to secure a certain degree of stability. And the individual responsibility was part of practice, was left to practice, and some authors did consider that ministers should not resign anymore if if their individual responsibility was at stake, although we had some controversy. For example, I could refer to visas which were delivered by a minister in circumstances which were deemed to be completely inappropriate. Well, should it trigger off the resignation of the minister in question? We will come back on that, but it is only when a member of the parliament did raise the issue of individual responsibility that the issue was taken into consideration. I'm not going to go into all the details, but the individual distrust motion, which is deemed to be constructive, means that some MPs from the opposition have to determine whether or not someone would be in a position to act better than the person in place. And this type of situation was really highly criticized. And in 2017, the collective responsibility was mentioned. If you want to question and challenge the responsibility of one single minister, instead of having to appoint a successor, you have the possibility to ask for the whole government to resign except the successor. It was admitted, indeed, by the services of the Walloon Parliament. So it is a collective responsibility which is supposed to replace individual responsibility, although the borders and the scope is quite blurred. Well, when we do invite foreign people, usually we don't talk about Brussels, the Brussels government, because I don't know how COCOM has to be spelled or said in English. Well, because it is an acronym which is quite difficult to translate. So I'm not going to talk about Brussels to avoid any problem. Now I'm going to refer to individual responsibility again. As mentioned before, it is a matter of charge and a matter of limitation of the members of the Council to 15, because for preparatory works we want to avoid a dilution of responsibilities, and ideally we would not like to have 14 different departments with one minister in charge of each department, so that we can create a direct linkage between the department and the minister and the responsibilities. We decided to stick to those figures, although some reforms, state reforms did take place. But this type of approach is not always respected, meaning that if you have a certain amount of departments, it does not mean that we will have sub-departments appointed, and at the Dutch level it is indeed the case. They've decided to subdivide some responsibilities, and at the level of the Dutch Parliament government, we can see that there is a lack of consistency between the structure of the different levels of power. And in some cases, the co-decision making procedure is also organized by the government. The best example is COCOM, but as I said a while ago, I'm not going to further elaborate on that, because it's so difficult to translate this acronym COCOM and what is behind it. And immediately after that, I will refer to my colleague, because I'm not supposed to talk about parliamentary law. We also have a series of tools, actually, which are meant to escape the issue of individual responsibility by raising collective responsibility issues with a simple motion. For example, we had this case with the Ministry of Foreign Affairs, who issued visas which were deemed to be inappropriate. It is a motion which is adopted after question raised on the occasion of a hearing, and it should have a priority regarding other motions. And if you do adopt a simple motion, it will prevail over all the other motions. So the main strength of this motion is to avoid having to deal with the issue of individual responsibility. So sometimes in the majority, sometimes people might be a bit reluctant to support one person whose behavior is deemed to be inappropriate. We don't have to deal with the issue of trust and we can proceed immediately with the next item on the agenda, because in this very case the objective was to relate the responsibility of one minister to the collective responsibility of the government. But this type of technique, this simple motion, as we call it, makes it possible for MPs to avoid this issue of responsibility, to simply bypass it. People say, well, I just voted this simple motion, but I don't trust this minister. I'm not going to mention her name because she's supposed to get a very interesting portfolio at the European level, so I'm not going to mention her name. But that's something which was related to this issue of trust. And now I would like to give the floor to Julian. Well, thank you very much, Mathias. And you have the opportunity to listen to Mathias in a while, although he spoke more than planned initially. Well, it's quite important to see what is the articulation between the collective element and the individual element in terms of responsibility. And this might create a kind of articulation between the responsibility of the ministry and of the Prime Minister and the government. The responsibility of the Prime Minister increased over time. So it does. The Prime Minister does embody to a certain extent the responsibility of the government. He is the representative of the government in front of the House of Representatives. We have, for example, the governmental statement, a speech delivered by the Prime Minister. We have the State of the Union speech, which is also delivered by the Prime Minister. And the Prime Minister is also supposed to answer some questions raised by the MPs. And of course, it's quite interesting to note that there is another element which does indicate that the Prime Minister is the representative of the government. He or she is the one who can raise the issue of the trust, the motion of trust regarding the government. But the most important element regarding the responsibility of the Prime Minister and the government is that the resignation of the Prime Minister will automatically lead to the resignation of the whole government. Herman Van Rompuy in 2009 did resign with a view to become the chair of the European Council, and it meant that the whole government had to resign. And therefore, the successor to the Prime Minister, Yves Le Terme, had to set up a new government, although it was with the same people than in the previous government, and he had to ask again for this vote of confidence to the government. So it's very interesting to see the articulation of individual elements and collective elements in this very case. So the resignation of the Prime Minister meant the resignation of the whole government, but it's not necessarily the case for the federal entities. there is a different system which does frame the level of responsibility of the different ministers. So in that particular case, we will have rules which are completely different from the other rules, i.e. the rules implemented in the case of the government. Well, a very last point, which is also quite interesting regarding the notion of collective or individual responsibility, is the following. Actually, the Prime Minister is the representative, is the master of governmental or ministerial solidarity. So he's the one who is supposed to articulate this solidarity. And it might be translated into a series of constitutional rules. I told you that the Prime Minister is the only one who can raise the issue of confidence regarding the government, but he is also the only one who can raise this particular point regarding ministers taken individually. And the Prime Minister has also a say regarding the possibility to revoke ministers. In this particular field, we need to mention the specific role played by the Prime Minister, because he has the opportunity to support or not a minister who would be faced with problems or difficulties. Another point, another element which might allow us to give a very good illustration of collective and individual responsibility has to do with the collective consequences of individual resignations. So we have two parts here. We have, first of all, what the implications of the individual the individual resignation might have an impact on the government as a whole. Individually, we might be faced with a series of difficulties regarding rules applicable, for example, in terms of languages spoken by the minister, or the amount of ministers present within the executive, or gender quota. In that particular case, the resignation of one individual minister might have an impact and an implication on the collective approach, given all the prerequisites I've just mentioned. Still, regarding individual resignation, this might have an impact on the way the government does operate. Well, just to give you an example, if the minister who is supposed to resign is the only representative of a political party in the coalition, in that particular case, there is a possibility to have a collective responsibility in case, for example, it would mean the fact that the governmental coalition would lose its majority. And it is important to mention that because the constitutional law does not provide a clear-cut answer about all the consequences of individual resignation or individual withdrawal. Do we consider that the individual resignation of the minister might lead to a collective resignation, or will it induce the need to tackle with urgent and important matters only, or should we consider that it will impact the only portfolio of the minister concerned? So, as a conclusion to this very first part, I would say that the individual responsibility does melt into the collective responsibility, does mirror the reality, but does not give anyway a full overview of the reality. And the assumption made by Mathias at the very beginning of his exposé is the following. The deficit in terms of understanding and in terms of the theory, or from a theoretical point of view, does pave the way indeed to a kind of weakening of the individual political responsibility. And it does open the door to a series of practices which will lead to a kind of exemption in the field of responsibilities and individual responsibilities. Sometimes it is made possible thanks to the constitutional law, but it is also made possible by a series of vacuums identified at the level of the constitutional law. Given that we don't have more time available, I will try anyway to cover the 4 examples of exemptions. And I feel that, well, I'm sorry, but the mic does not work. Well, Matthias was supposed to refer to those different examples of exemptions, and the underlying rules are the fact that the administration would have to bear with the responsibility of the minister, because the responsibility of what other people do is something which is deeply rooted indeed in the Belgian way to operate. But Matthias will have the opportunity to further elaborate on that. There is also a possibility to blame the predecessor for a political action or a problem. And it does raise the issue of a kind of posthumous political responsibility mentioned by Olivier Beaune, and we're on the same page than him. We do consider it is a very good point. But when you resign as a minister, it means that you're a former minister and that you do not have any more political responsibility to endorse. Why? Simply because the responsibility is the element deriving from your portfolio and your appointment. And if you don't have this responsibility or this office anymore, it means that you are exempted from the responsibility. We also refer to the fact that in some cases resignation is a kind of sanction, and it is impossible to remove an office previously covered by a minister. But anyway, some accountability might be needed or might be possible. So the situation is quite paradoxical anyway regarding the notion of posthumous political responsibility. It might be a factor which would reduce responsibilities or expand responsibilities. Well, to factor limiting responsibilities. Why? Well, simply because a minister can consider that he or she is not responsible for the dysfunctioning of actions adopted by a previous minister, by the predecessor. And in that particular case, we can blame the predecessor for the problems. But we might also have an expansion of political responsibility with the possibility for the parliament to ask for some feedback to the minister in charge and to convene the former minister to a meeting, provided, of course, he or she is still alive. But this kind of practice is not a theoretical, it is something which is fully possible. We have, for example, some parliamentary investigations which might take place, and in that particular case, we can convene to the parliament the former minister as well as the one in charge. In the same vein, I would say that the third element would be to consider that you don't have to report back on anything because you have resigned. And it is fully related to the previous case. The minister did resign, but anyway still has a mandate to fulfill. And in that particular case, there is one rule. It is impossible to invite ministers who have resigned collectively to resign again. So we don't shoot on the ambulance. That's a principle which is well established. Well, I think that what we are talking about are are zombies, actually, because we talk about the former minister and the one who resigned. And in both cases, ministers don't have any more trust, but are still liable in terms of some responsibilities. So the constitutional law does disconnect the issue of trust and the issue of responsibility. But in that particular case, we need to determine what it means to be in charge without having any confidence or any trust. And in that particular case, we have some contradictions and some potential evolutions. I feel I'm under pressure, because I need to conclude. But anyway, I'm given the green light to conclude. Well, I'd like to insist upon the fact that we have some contradictions in the constitutional law. Initially, we did consider that a minister who had resigned was not supposed to answer questions raised during a plenary session. Now the situation has changed. It is fully acceptable to answer potential questions, but in the case of ministers who have resigned, you cannot ask questions to a minister who has resigned, and it is clearly mentioned in the regulation of the chamber. So when the resignation is accepted, all the questions which might be raised, all the motions related to this minister will be void and not applicable. Well, of course, we can wonder what is the reason of such a choice. And we need to bear in mind the fact that some elements are still possible, or some possibilities are still available when the government is supposed to tackle with urgent issues. And Céline did insist upon the fact that it is a way to test this relationship of trust of a government on a specific topic, and this might lead finally to the individual blame on a minister, because the right to start an investigation will make it possible for the minister to resign, but will prevent us from raising questions. So very swiftly, I would like to tackle the very last practice of exemption. And I will not further elaborate on that, but I will try to be as brief as possible. Because a minister could insist upon the fact that the things you are blaming me for have to do with my private life. It has nothing to do with my office. So we go out of the scope of my office. And according to the constitutional law, we have a series of milestones which have been set, as it is the case for the questions. We have some inadmissibility rules which might apply, and in this very case we know it is something quite theoretical, because that's the kind of obstacle we can easily bypass, and it is quite often the case for those of you who are familiar with the P-gate, let's put it this way. If you need further explanations, turn to the Belgian people in the audience. And this was a very good illustration of this notion of exemplarity, because there was a kind of tension between the political the ministerial obligation and duties, and this element of exemplarity. Well, so let's refer to the political and individual responsibility. We hope that in the future it will allow us to better frame the practices, and for the constitutional doctrine, let's hope it will allow us not to be limited by limitations and limitating elements. and I hope that this will not create any prophecy regarding a disaggregation of those responsibilities. I would like to refer to Jean-Michel Blanquer in 2000, who said the crisis of political responsibility is before anything else a crisis of the individual responsibility, a way for us to satisfy a need for responsibility.